That comes a lot.
Yes. The case of suit number OAL-MCC/25/26 between Baltimore Multinational Oil Company and the National Oil Spill Detection and Response Agency, NOSDRA, and Alliance. Our parties in court.
Hello, yes, Paris and court.
Yes, appearances.
With profound respect to this justice,
OR. Packaging stores. Yeah, appearances. Yes. Yes.
With profound respect to the Honorable Court, announcing appearance is P.S. Amike. A-M-I-K-E. And appearing alongside me is M.A. Adedayo. M.A. Adedayo.
Yes.
Our humble appearance is for the defendant in today's proceedings.
Yes. Yes.
My Lord, the case before this honorable court is a suit filed by Baltimore Multinational Oil Company. And we have a memorial for this honorable court, and we are seeking for the court to adopt this memorial filed on 3rd of June 2025 and serve that we seek for the court to adopt it as our final defense.
You are speaking to the court. You are representing the claimants and you are representing the defendants. The memorial is like your personal address, which is in fact. And in any civil action, who adopts first, who adopts first? The civil action. Who is supposed to adopt the first civil action? Is it the plaintiff or the defendant? Who addresses the court, plaintiff or the defendant? So the defendant is the first person to address the court because they are the one that has the cause of action. Then you adopt, and you then have the right to address, but they file your written addresses, they file after the 7 days, termination. You also have the right of under the law, for offense of God. But let me allow you to do the second to make the
Drafted 5 issues for examination before this order.
Your written address is stated when stated that's how you start, and you just have 2 minutes to adjourn. So your written address is stated, dated, yes.
My written address before this court is stated June 2025.
3rd June
addressing the court on issue 1, 3, and 4. Why not the researchers and address the court on issue 2 and 5? This is the court. My Lord, the first issue for determination of this is as the consciously drafted for the court to determine whether the complete collapse, partial collapse, or collapse of the houses are directly caused by the semi-glass carried out by GMC as by the Multinational Oil Corporation. My Lord, it is an open submission before this honorable court that the collapse and destruction of houses were not caused by the semi-glass by my client GMC. In light of the provision of Section 11, subsection 5 of the Oil Pipeline Act and the principles of causation and promoteness under the common law. To start with, my Lord, Section 11, subsection 5, paragraph 6 of the Oil Pipeline Act 1990 provides that a licensee, which in this case is by no multinational company, is liable to pay compensation only when the damage or suffering of the victim is caused by the leakage or breakage of pipeline of the company. My Lord, paragraph B of that same section provides that the company will be liable only when the suffering of the defendant is as a result of the negligence of the company, my Lord. My Lord, the effect of this provision is that the company will only be liable where the suffering of the defendant is as a result of the direct act of the plaintiff, in this case, my Lord. However, my Lord, it is important to note that the mere fact that there was certain glass by our client does not mean this certain glass resulted into the destruction of the house. My Lord, it is incumbent on the defendant to show that there is a direct causation, there is a link between the glass by my client in this case and the destruction of the houses, my Lord. Also, this decision has been judicially endorsed by the court in Moot versus Udo, citation to be provided, my Lord. Where the court held that it is the liability of the defendant to show that there is a direct causation between the act of the company and the destruction claimed in that particular case, my Lord. My Lord, applying this rule to the fact of the case, the mere fact that there was an occurrence of a glass does not automatically impute liability of collateral damages on my client, my Lord. Furthermore, the principle of remoteness under the common law shows that a party will not be liable if the causes or injuries are remote or unforeseeable. My Lord, the fact of this case clearly shows that the destruction of property results in 250,000 property being destroyed. My Lord, this amount of destruction is unforeseeable and therefore shows in itself that there are other circumstances which resulted in this destruction beyond the certain glass by my client in this case, my Lord. My Lord, proceeding to issue 3 in this case. Issue 3 has been partially drafted for this court to determine whether Nostra has the statutory power to impose the fine, the $3.6 million fine on Platform Multinational Oil Company. It is my humble submission before this honorable court that Nostra has this power based on the principle of separation of power and by virtue of Nostra which established and defined the power of Nostra. To start with, my Lord, Section 6 and 7 of Nostra Establishment Act states the functions and special functions of this body. My Lord, specifically, Section 6, subsection 1, paragraph B provides that Nostra shall receive reports of oil spillage and provide response to this oil spillage. Additionally, my Lord, Section 7, subsection A provides that Nostra shall coordinate and implement the National Oil Spill Contingency Plan. My Lord, the provisions of these sections is expressed, and it shows that the power of Nostra is only supervisory, my Lord. My Lord, the power is not adjudicatory in any nature, and by the imposition of fine, Nostra has also protected his power and has actual controversies. My Lord, it is important to note that the principle of separation of power under rule of law clearly separates the power of different organs of government. My Lord, by virtue of Section 6 of the Constitution of the Federal Republic of Nigeria, it is shown that it is the court that has the power of adjudication, which also includes the power to impose fine. Therefore, the imposition of fine by Nostra in this case is an usurpation of the power of the court and constitutes for trials. We therefore call this honorable court to dismiss to declare the fine as null and void and of no effect whatsoever. My Lord, proceeding to my final argument on issue 4. My Lord, issue 4 has been consciously drafted for the court to determine whether the action of Guatemala multinational against Nostra is statute barred under the Public Officers Protection Act. My Lord, it is our humble submission that this action is not statute barred for 3 main reasons. First, my Lord, the Public Officers Protection Act applies expressly to public officers, my Lord. And public officers is expressly defined under Part 2 of the 5th Schedule of the 1999 Constitution. My Lord, Nostra is not a public officer within the purview of this provision of the Constitution. It is a mere agency and a corporate body. My Lord, it has been established in a plethora of authorities, including NDIC versus Kewara and citations duly provided, my Lord. That statutory agencies or corporate bodies are distinct legal entities and are not public officers for the purposes of immunity under the statute of POPA, that's Public Officers Protection Act. This therefore shows, my Lord, that this act does not apply in any way to Nostra because they are not public officers. Secondly, my Lord, as we was not conceding that the act applies to Nostra, the time frame given under the act has not elapsed. My Lord, the act expressly provides that the time frame given is 3 months. However, when the action is continuing in nature, my Lord, that particular time frame cannot set to have lapsed, my Lord. My Lord, the fact that Nostra imposed fine on my client is a continuing act because they have taken continuing action to implement this imposition of fine. My Lord, this is a continuing act, and therefore the time frame provided for under the act cannot be said to have lapsed, my Lord. I told you, my Lord, it is important to note that even if the court were to consider OPA applicable in this act, OPA is not applicable as stated under the act in cases of bad faith. My Lord, the mere fact that the defendant in this case, Nostra, has acted ultra-virus and continue to impose fine on my clients, even when they cannot prove that my client is liable, shows that they are acting in bad faith, and those the act does not apply to them as a limitation provided under the act. My Lord, this position has been noted by colleagues in the case of Federal Republic of Nigeria versus Central Energy Limited. Therefore, my Lord, applying this principle to the fact of the case, it is important to know that OPA does not apply to Nostra. And even if it applies to Nostra, the limitation provided under the Act is not applicable to this case on the ground that the time stated as not lapsed due to the continuation of the Act of Nostra in this case. And as a result of bad faith by Nostra, my Lord, it is on this basis, therefore, that I seek the leave of the Honorable Court to defer the legal arguments on issue 2 and 5 to my co-counsel in this case.
Yes.
Thank you, my Lord. Before I go into the issue 2 and 5 of this case, I would like to seek leave of the court to put in record that the defendants just served us their judgment, and it will be a just of justice for us to continue this case. My Lord, we have served the defendants our case long before now. So the action of them serving their case now, my Lord, it will be in interest of justice. My Lord, it is important that justice is not just done, but justice seems to be done, my Lord. Now, I'd like to go to my issues.
So do you want the court to answer what you have just said? We are not asking the court to keep it.
Yes.
To keep it where the regular, the court doesn't have to. Your observation or your argument that you have just canvassed ought to have been done before your argument started at all. So it's like crying now after the look at the spirit. If you knew you were just asked and you needed time to react to the memorial that you had observed, that would have been the first thing you would have observed before all that going to the area. So you may please proceed with your arguments.
As a government, and I'm facing on issue two, whether GMOC acted negligently in excess of its duties under the Environment about the condition of the claimant that GMOC is not acting negligently.
You need to be more audible.
My Lord, before there are conditions that are necessary to prove the act of negligence. My Lord, number one, duty of care. Number two, breach of that duty of care. And that breach of that duty of care leads to damages. My Lord, in the case of night birds, Birmingham Worker Work School, solutions will be provided if you found out light solutions. The omission to do something which a reasonable man guided upon those considerations, which originally regulate the conduct of human affairs, would do, or doing something which included a reasonable man would not do. My Lord, this case was so highlighted in major cases of animal laborers to general hospital environment. My Lord, in this last case, the body relies on the defendant to prove that the claimant in this case was negligent. My Lord, it is not enough for the defendant to allege negligence. They must prove with clear evidence, my Lord, that there was negligence. My Lord, this was needed in the case of Shell Petrol Development Company of Nigeria Limited. There's clear, my Lord, suggestion to be provided. The court of appeal held that company engaged in cultural operations is not time for alleged environmental damage unless plaintiff prove that damages was caused by them. Moreover, it is the condition of a plaintiff that the defendant must prove that negligence resulted from our actions. My Lord, it is not important that GMOC carried out the process of law under section 102 of the Petroleum and Industrial Act, which states that petroleum organizations must submit an approval of submit a proposal for approval on environmental management plan. My Lord, is a condition of the claimant that we have carried out the process of law, and this is stated in the attached to the evidence in our memorial. My Lord, moving forward, just by complying with environmental regulations and obtaining all necessary permits and impact assessment, including approval of the project, because my Lord, in corporate we are cash affordable. You have received approval from the Director of the National Union of Petroleum upstream petroleum to the midstream regulation, my Lord. My Lord, the court has long held that compliance with regulatory frameworks constitutes evidence of due diligence. My Lord, in the case of all defense very industrial limited, the court held that a practical act in accordance with applicable industrial regulations cannot be held negligent, my Lord. My Lord, in the light of foregoing, I will be conclusion that we have had our due process of law and the project of defendants to prove that we are negligent in this case. My Lord, the second last issue I was talking on is the issue of local scandal. My Lord, it has been put in to Alex Sawyer expressing that local scandal is a critical jurisdiction of the court. My Lord, if a party doesn't have the local scandal to seek an action, the court cannot move forward with the case. My Lord, local scandal has been defined to mean interest, direct or substantial interest in the proceedings of the case, my Lord. My Lord, the confession of the claimant that the community, and the collective is neither a natural person or juristic person, my Lord, and thus cannot take an action or seek to be joined as a party in this case, my Lord. My Lord, moving forward. Furthermore, in the case of AG or State Federation, because clarifies that the purpose of the local standard is to prevent frivolous or vexatious implications by parties who have no direct stake in the outcome. My Lord, it's important to know that local standard is not a blanket for all. My Lord, it's a threshold that will be satisfied before insisting an action in court, my Lord. My Lord, after this peaceful case,
Respectfully, my Lord, as earlier introduced by our PS. My Lord, before proceeding to the merit and substance of our case, we would like to seek the leave of this honorable court to adopt our brief of argument, which was filed on the 3rd of June 2025 and duly served on the claimant in today's proceedings. My Lord, the Honorable Commission, we seek that our brief of argument, which constitutes our final address.
Mr. Anike, your brief was filed on the 3rd of June, but you omitted to say when it is given. It is the date of the filing. So if you will come again, your brief is dated and filed.
Respectfully guided, my Lord.
Yes.
I receipt to address. Respectfully, your Lord, throughout today's proceedings, we will demonstrate that in line with constitutional principles, that today's case is one where our client, Mostra, has not acted outside the scope of its power. And as such, there are 4 main issues which were formulated for determination before this court. My Lord, respectfully, I will be addressing the first 2 issues. The first issue which borders on whether the total partial collapse or cracks of houses in Ogu community is directly linked to the seismic activities of GMOC, that is Bajumo Multinational Oil Company. And if that is the affirmative, my Lord, the question of whether they acted negligently. My Lord, it is our submission that the claimant in today's proceedings acted negligently by committing activities which put over 250,000 households in jeopardy. And also we submit that it did not only contravene the Oil Pipelines Act or Mothers Act, but they also acted negligently, contravening common law principles. My Lord, our first submission is this: to recognize the powers of Mothers in Section 5, 6, and 7, which grants the authority to impose certain levies. But respectfully, my Lord, we also recognize the fact that the seismic blast in question is not something which is directly provided for under the Nostra Act. However, my Lord, in the Oil Pipelines Act, it has been carefully enumerated that every environmental damages in question which flow from the activity of a licensee or a lessee is something which the court would hold those lessee or licensee liable of. My Lord, in order to prove causation in this case, we have to rely make recourse to provisions, common law principles of Donogo and Stevenson, where the court established that in order to prove negligence, 4 main elements will be established. First, that there has to be a duty of care. Second, that there was a breach of that duty of care. And third, that there was causation. And third, there was reasonable foreseeability of damages. My Lord, because of the way this issue has been couched, causation shall first be determined, and before then we will now proceed to determine whether they acted negligently. My Lord, our submission is simple in this case. We rely on the but-for test. The but-for test has been established in the case of Barnett vs. Chelsea and Kensington Hospital Management Committee, where it was stated that the main question before the court should be whether the damages in question would have arisen if not for the activities or the actions of the claimant. My Lord, in today's proceedings, it's not a question of whether or not it was reasonably foreseeable. It is a question of what happened to the livelihood of 250,000 people. My Lord, we submit that relying on the proximity of time and place, especially for the fact that it is clearly stated in the Moot fact that GMOC operates an oil well in that community, and also considering the fact that in order for oil companies to explore oil, they would use seismic activities to track reservoir oil and to ensure that they are able to get oil. My Lord, in line with this proximity and the non-availability of alternative credible explanation from the claimant in today's proceeding, we submit that they are indeed the cause of this collapse of houses in Ogu community. My Lord, even if they talk about the non-reasonable foreseeability of this damage, my Lord, we rely on the egg-shell score principle, which talks about the fact that you must take your claimant as you find them, even if Bayelsa or the community in question is one which is prone to attacks or prone to environmental degradation. but the singular fact that the seismic activity was a trigger which put the lives of 250,000 people in jeopardy is enough, and we submit that this court should put in by relying on the ex-culture principle that says you must take your victim as you find them. Respectfully, your Lordship, this concludes my submission on the first issue, and I will now move on to the second key issue before the court today. My Lord, the second key issue is whether Nostra had the statutory authority or power to impose a penalty or levy of $3.6 billion on the claimants. Respectfully, your Lordship, we understand by virtue of Section 5, 6, and 7 of the We understand that by virtue of Section 5, 6, and 7 of the Nostra Act, that Nostra is vested with statutory authority to impose penalty and levels for pollutions. My Lord, pollutions are not to be defined in their literal meaning. My Lord, if you make recourse to the provisions of the oil pipelines which provides for the fact that when pollutions emanate from the activities of any oil licensee or lessee, that these people should be made to pay remediation or should be made to work to pay cleanup. My Lord, what is simply happening in today's proceedings is that we have simply brought the multinational oil company to this court, not just to answer for the determination of whether or not there is a contravention or separation of power, but to question or to look at the gravity of what has happened today. My Lord, the case before us today is one of humanitarian crisis, and if we had relied on or have waited earnestly for them to have instituted a case which would take maybe 2 months, 3 months, 4 months, or even 5 months, sometimes years, my Lord, over 250,000 people would have no remedy. But it is not a case of legal mechanisms. It is a case of humanity. It is a case of environmental remediation. Secondly, my Lord, we submit that the levy in question is mainly compensatory and it does not seek to punish. And as such, the argument on the other side that it goes against judicial powers by contravening the separation of power is not valid in today's proceeding. My Lord, we rely on Section 19, sub 1E of the amended Nostra Act, which says that they have the power to ensure compensation for environmental damages. My Lord, we submit that the $3.6 billion that have been offered today, or that have been imposed on the claimant, is merely for the compensation of the 250,000 people who have been displaced. My Lord, we rely on the case of the Federal High Court decision in Shell Nigeria Exploration Company versus Nostra, where the court upheld the Nostra's power to levy sums for compensation and even punitive damage. My Lord, moving on to my next submission. We already anticipated that we were going to raise the issue of judicial powers, but we contend today, my Lord, that today's case is not one of judicial powers, but it is one of administrative enforcement of remedies. My Lord, in order for us to get swift response and accountability in cases of major environmental damages, we cannot always rely on the court for us to seek redress and make our amends in all these cases. My Lord, if you come back to Nigerian reality, the AFCC imposes fines, even the CBN to certain extent imposes certain fines. All of this is in line with their regulatory powers, in line with their enabling act. My Lord, all of this is to show that they are powers. My Lord, would also like to state that while they might rely extensively on the position of the court in Nostra and Mobile Producing Nigeria Limited to state that Nostra has no power to impose levies or penalty on claimants like this, we submit respectfully, my Lord, that in today's proceeding, that the reason for this overwhelming penalty or imposition is because of the large victim population and the sheer scale of the environmental disaster, my Lord. My Lord, 250,000 people, that means women, that means children, that means lives that have been lost, that means schools that have been destroyed, and that might mean generations that might be displaced forever. My Lord, this is not one of quantification, it is a one of reality, one where the court has been called to determine whether we are able to address the humanitarian and environmental crisis. Lastly, my Lord, we submit that even if we do not contend on this point, that Section 29 of the Land Use Act already provides for what we call unlawful alienation. Respectfully, my Lord, the principles in Section 29 of the Land Use Act states that provides for unexhausted improvements, which includes buildings, when a right of occupancy is revoked. Respectfully, my Lord, we submit that all exploration activities which have caused such catastrophic issues, or which has caused debilitating harm to a community, resulting in displacement of over 250,000 homes and rendering people uninhabitable, is one which has led to a de facto revocation or frustration of the community members' right of occupancy. My lord, this means that the compensation in question which we are requesting for is only aligning with the similar principles of restoring the value of the destroyed properties. My lord, this is clear and is sacrosanct. Respectfully, my lord, we also like to point the attention of this court to section 111 sub 3 of the PIE, who states that a licensee or lessee who in the course of their petroleum operation causes damage by injuring or destroying buildings or any other property, or who disturb the surface of any land, shall pay fair and adequate compensation to persons or community affected. My lord, we submit that the alleged destruction of over 250 homes is well captured in this provision. My lord, this concludes my submission on the first two issues. And if there are no clarifications on this honorable court, I will now defer proceedings to my co-counsel, M.A. Adedayo, to address this court on the substantive issue 3 and 4.
Yes.
With profound respect to this honorable temple of justice, my name is M.A. Adedayo, and in the next 10 minutes, I shall be adjumbrating on the last two issues in merit. My lord, apologies, my lord. It appears my co-counsel allotted our time before we started speaking.
Yes, I said 15 minutes. That's the time I allotted.
Oh, for him, my
For
lord.
each.
Of course.
For each side. So, but I allowed to proceed, but it seems you are taking over the time given by itself. I say you sought the responsibility of the court to itself.
My lord, I would like clarification on whether you knew that I may speak for 15 minutes as an individual speaker. Or you
No,
knew-
I said the defense may speak for 15 minutes.
My lord, in the interest of justice, we would request additional minutes in the court's discretion.
So how does that affect the interest of justice?
So that the defense will be adequately heard on the issue. Saying that
I want to know how it affects the interest. Since the 15 minutes were allotted to the claimants, and then the same amount of time is allotted. So maybe the interest of justice will give more time and I'm giving to the claimants.
well guided, my lord, most guided by God's will.
However, I allow them to finish up my duties and I don't say that. They're just a guide and you don't give the court a time limit. This is the court that gives you time. So you're starting by saying that you are taking 10 minutes. You don't know if the court has 10 minutes to do. So you watch against that in future.
Most gracious. Thank you.
Yes, proceed.
My lord, 500 years ago, the following words were said: Solitudinum, facium, pacet, appellant. They destroy our land, they take our livelihood, and in exchange, they give us granite. My lord, this is true today, and this is exactly what GMOs, the applicants in this case, has done. As such, my lords, the last two issues relate firstly to whether the fact that the Odu community is recognized under international law as stakeholders, for example, the UN Convention on Indigenous People, makes it impossible for them to approach this honorable court simply because they receive a minute amount of money within the meaning of the Petroleum Industry Act. That, my lord, is the actual issue before this court, not necessarily the issue of local standing. However, my lord, the defendant will be taking on the burden of responding on this issue regardless. My lord, on this issue first, we like to make our case by saying that the doctrine of stakeholdership recognized under the Unitary Convention of the United Nations is premised on the principle of fair, informed, and free consent of indigenous people. The Ogu people are indigenous people, my lord, of Bayelsa State. the law requires that they are consulted before anything is done on their land. The Petroleum Industry Act recognizes this principle, and that is why they are recognized as stakeholders. But the relationship, my Lord, may have been modeled, and your brothers in the Federal High Court clarified on this, what constitutes stakeholdership within the meaning of the Petroleum Industry Act, and whether granting of 3% of the producing of the expenditure of the applicants in this case strips them, the Ogu community people, from being able to come to court. And the answer is no. In 2 cases, your brothers have stated, in the case of Prince Ekinye versus Shell,
Whose brothers?
the Federal High Court,
Whose brothers?
your Lordship, your brothers at the bench, stated that, my Lord,
I asked them, whose brothers?
your learned brothers,
Whose brothers?
my Lord, if I may be guided by this court on what your question is.
On diction, on language, you have to be following it. You don't address the court in such a way. How can you be addressing the court in your official language, saying your brothers?
Thank you. Most guided. Apologies.
Please, the title is not your brothers. You're not a familiar school.
Most guided.
Yes.
It has been decided in these cases that the relationship that exists between them is not such that would strip the indigenous communities of their rights to come to court, as that would be contrary to the intention of the drafters of Section 6 of 6B of the 1999 Constitution. My lords, the applicant wants to invite you to come to the conclusion that the fact that these people receive a token within the meaning of Section 240 of the Petroleum Industry Act, that is 3%, my Lord, denies them the opportunity to approach the court to obtain adequate compensation and damages. My Lord, the answer to this should be no. My Lord, we rely on the authority of the Supreme Court's decision NNPC versus Oil Pollution Watch, where the court held that victims of environmental protection cases may approach this the court to seek compensation and damages where adequate. However, my Lord, in order to evade the real question that was posed before this honorable court, the applicant simply addressed the issue of local standing. But even the issue of local standing, my Lord, is already well settled, particularly when it relates to communities such as this one. My Lord, from this we argue, relying on the Ogoni case, my Lord, that indigenous people can come before this honorable court, and that unlike in the case of Akilu versus Faroini, older day cases, those cases no longer apply, my Lord, because the decisions of the court over the years, relying on Section 6 of 6B of the Constitution, has been that the court can adjudicate on any issue concerning any person. As such as our submission, in response to the argument that this argument and that the Ogo people who have been unjustly, whose home have been unjustly taken from them, as has been established by my co-counsel, have a right to approach this court to seek the adequate remedy. My Lord, having addressed this issue, counsel will now proceed to the last issue, which is on the question of whether this case is barred on the basis of Section 2A of the Public Officer Protection Act, POPA. My Lord, before making submission on this issue, it is important to trace the historical evolution of what is now codified in Section 2A of POPA. My Lord, back in England, the principle was that the king can do no wrong. My Lord, this principle has been extended, my Lord, even to public institutions of government. My Lord, as a consequence of this, any case that is instituted after 3 months may not be heard by a court. The reason for this is not to distract public officers in the ordinary course of their duty and to prevent the floodgates, my Lord. My Lord, as a result of this, Section 4 of the Nostra Act also recognizes this and it puts a body on the applicant to institute the case within 3 months. However, they have failed to do so, my Lord. And in response, they have made 2 arguments. The first is that Nostra is not the public officer within the meaning of the Act. The second is that the act in question is a continuing act. And the last is that Nostra has acted in part. My Lord, we ask you to discountenance all these arguments on the weight of our submissions. On the first argument, which is whether Nostra is a public officer, my Lord, the law is quite clear. Section 18 of the Interpretation Act says the public officer is any official of the law. And over the years, public institutions have also been recognized by the Supreme Court to constitute public officers within the meaning of the Act. Authorities such as Unijust versus Ikego and Kastandudu versus Ultimate Petroleum are clear on this point. As such, my Lord, it's our submission that natural and artificial entities such as Nostra can also come within the meaning of Public Officers Act. As such, my Lord, since this case was instituted after 3 months, which the plaintiff do not contest, it's our submission that this case may not be heard on. My Lord, on their second argument, which is continuing act, what the applicant have failed to note is a resounding decision of the Supreme Court in the case of Akonde versus Akin. In that case, my Lord, the Supreme Court stated that although continuing act is an exception to the application of the Public Officers Act, however, we must distinguish between the effects of the act and the continuance of the act itself. My Lord, in the present case, it's our submission that the act, first, the legal injury that the applicant claims constitutes the act is not a continuing act. Rather, at best, what they have is the effect of the act. My Lord, there has been nowhere in the fact, as it has been stated, that the Nostra has been forcing the GMOC to pay the fine. The payment of the fine is a legal obligation, my Lord. As such, they are supposed to comply with it. This does not constitute a legal injury. All we have done is impose a fine on them in accordance with the law. As such, it's our submission that there is no continuing act here. The effect of an act is distinct from the act. As such, my Lord, discountenance is argument. On their last submission, which is bad faith, they made a presumption, my Lord, that we cannot prove that we are not lying. However, my co-counsel has proven to me, through systematic submissions, proving first that technologically and as well as from a legal perspective, it is very likely that this company is responsible for the seismic activity that denied 250,000 people their homes. My Lord, in context, this is thousands of family members displaced within Nigeria, without home, without refuge. As such, it's our submission that there is no bad faith here. We have only asked for them to pay for what they have done by imposing $3 billion. My Lord, as such, based on this submission, in response to the arguments of the applicant, we ask this court to decide in our favor. My Lord, in terms of the remedy, we ask this honorable court to adopt our prayers as contained in our remedy. If I am of no further assistance to this honorable court, we will now rest our case.
Yes.
Thank you.
Yes. Point of law. I can't hear you.
I see the honorable court to defend the report of my counsel.
To defend.
To defend
To defend
my co-counsel.
to your co-counsel. Yes, on point of law. Yes.
My Lord, Section 131 of the Code of Evidence states that a person who has started a task to must prove that that fact exists. My Lord, the condition is that the defender has failed to prove directly,
On point of law.
Yes, ma'am. My Lord, in case of the whole estate, the top that must be quoted on the record.
Are you going back to trial? They have a duty to do.
Ma'am, stating that they failed to prove and packing their points on points of law and failed to prove directly about the defendant in this case, the possession of damages.
That stands on the point of law. That is your responsibility. You are the claimants. You are suing them for actions that they have done, which included the fact that they claimed that it is you that caused the damage. address these issues. Point of law has to do with maybe issues that were raised in their
They raised the issue of
you also raise the you raise the issue of jurisdiction first. You sued them, and jurisdiction is one of the issues you sued them on. You said they did not have the powers to act as they are acting. So it is your duty to have established that, and you do not have the power to act. They only reply to your allegations. So any matters arising from their any issue arising from the argument as to that is not the main issue that I want to react to. So thank you. Yes.
Highlighted the Foundation Act in different Republic officer. My lord, it is the question of the claimant that the security of the constitution was prevailed. My lord, the Republic of the officer has been playing different games to the Supreme Court.
You still do not appreciate what I've been trying to call your attention to. You have addressed these issues. All of these issues in your argument, they are not fresh. They are not issues that have been raised by the defense that you have no opportunity to react to. And you have a position of your own. You have the rights. You address the issue of the Public Officers Act. You address the issue of the interpretation. You address all of that in your argument. You talked about the responsibility of hospital. So is there anything that is new in what you are saying? So what has to do with the application act?
Stating that the application of the defender in the Public Officer Act is invalid and unavoidable, inconsistent with the definition of Public Officer Act under the Constitution.
Okay, you are saying the application act is not valid as a true definition of what the public officer has done. Well, I read that. I read that. I will read that to see whether it is invalid for the interpretation of the law.
My conviction is that the Constitution is supreme, and everyone that does that law assistant rules of the Constitution is not and what according to section 1 3 of the Constitution of the world. That's my position. Okay?
Now, I believe it should be time for judgment. Is it? Is it time for judgment? After adjournment of judgment, you are adjourned for judgment. Isn't it? But I'm not adjourned for judgment. I'm giving judgment. And my judgment is not going to be like the regular judgments that will be read because the way it is read, I will just address these, I've noted as a case, and I will pick them one after the other. Before I proceed, may I ask the organizers if I am opportune to add one more parameter to what I have before me? Dr. Bollywood, she's not here. Can I start? Okay, thank you. What is supposed to be deemed as your final meeting address? 20 your claimants. Let me ask the question. Okay, let me ask both of you a question. Please. Let me ask both of you a question. This matter is called before which one? Please approach. Please approach the conditions. Addition into please additions to it. So in your arguments, even somewhere you have made a mention of waiver somehow. So that it shows that you actually understand the duty of the court. Then the plaintiff claimant counsel, which exactly are you using plaintiff and using claimants? Yes.
This was the question I was giving to us on the
That's the question I was asking. Now, when you are writing out the names of parties, it is supposed to be in full, or not full. What is not full? When you are writing the names of parties, it is supposed to be in full. I'm addressing the plaintiff now. The defendants will actually wrote it correctly. You wrote the name of the parties. So you have to write the names of the parties. If you go through any of the law reporting platforms that you have, you will see that in reporting the names of parties are always written. And then when you are addressing the court and you're writing your final written addresses, you can see a lot of abbreviations here, like PIA, PTA, and all of that. What do they mean? Did you give an introduction as to what they mean, or PTA would mean, or whatever would mean? So when you are approaching the law, you make a reference to what you are saying, not that you put the law in short term. Yes. So that's the first part. Then diction. There is great importance to language before the court. You don't use the word you when you are addressing the court. You don't use you don't pass like I collected the letters and when said your word, the language you is not pass. Since you're not cheap, you are less important. So it's always a watch. You have to be very careful in your language because your language is enough to make the court not feel too comfortable and conclude that they are either rude or arrogant as a counsel. So diction is very important and respect is very important. And then you don't assume what the court has done to you. Like when you got up and you're telling me that you are taking 10 minutes. You don't assume. Then let's proceed to other things that is loaded and to the issues that you take the shop. Have you heard anything about actions found in representative capacity? Actions found in representative capacity? You know actions found in representative capacity? Who can find those actions in representative capacity?
For instance, the labor of family council on behalf of family, the committee, for instance, the king council on behalf of the community.
So what makes an exception of the community? I told you I'm not giving the regular documents. I will just address the issues because it's a new and more yes, but I will just address the issues. So in respect of the good community, we're talking about the local standard and their capacity to sue. Yes, they can file an action in the representative capacity. The law allows them to do an action in the representative capacity. So let's start on the first issue. Whether the complete collapse, partial collapse, or part of the houses in the court are facing flats, capital, and jealousy. I expected from your end, in your matters, to give a brief English as to what is settlement is all about. Whether it is something that is conducted on the land that has a collecting rights on houses and things like that. Because it is your claim as the claimant that your actions during the settlement has no impact whatsoever on the houses and lands and the properties of the community. Isn't it? So definitely in your argument you should do a little exposure on how a settlement plan is actually done and conducted and the impact. Settlement plan is like a water survey. It is dropped inside the water to below the sea level to source your oil and then you ought to have a connection between that and the land. The distance between the lot and the houses that are living on. If you're actually claiming that it is not a direct impact of what you are doing, have you shown enough to tell the court that it is actually not a direct impact? They have addressed that issue. They conducted an investigation as necessary, and they have come to the conclusion that it is your act that is possible, and that challenging that position or giving it that it is not your act. So rather than you shifting that in your reply upon your that they have the duty to show that it is your act that caused it. No, they are concluded. They are challenging that decision, and it is not your act. It is not your act that caused the damage. That you had the action of your company had no effect on what happens to you. That is your position. That is even the main issue because there is a business. But in your administration in everything, you have not shown why you believe and claim that that's what given by the defendant about your company isn't right. So rather than tell them, because your decision is that they are right to give them a report, and the conclusion of that report led to the decision of the fine on your company. Because their investigation review is what your action. So they are doing a conclusion. You are challenging that conclusion by coming to court. So if you duty them, you don't own the duty to tell the court that your actions and the statements that have nothing to do with the actual damage that was before, the actual damage that happened to the community. So that is on the one side. Yes, I know what you are referring to. Yes, it is not enough. Yes. Which evidence? You cannot access evidence to adoption of this evidence. That's the next point I was going to talk about. You are supposed to file something like an adoption of this evidence. It is deemed that they are giving evidence. It is deemed that all issues are confessed. They are giving evidence before the court and they are addressing the court. So it is not at the stage of the address that I will go back, that you will attach. Let me come here and let me explain. There are different stages of trial. Hello? Are you listening? There are stages of trial. First, you file your evidence. Isn't it? After listening and said, you go for trial. And trying all the witnesses. You tender all the evidence, both documentary and other. Isn't it? After that, you go for other trials. Isn't it? At this stage, I am told this is an option of and I'm supposed to assess your administration, your presentation of the address of the court, not your witness statements and the evidence that you have. And for clarification, when you file this address before the court, it is not at that stage that you attach list of evidence. It is not at that stage you attach plans, survey plans, and all the other plans that you attach. I can see environmental management plan PMP here, attached to your written application. I can see your list of witnesses. In fact, I can even see a certificate of identification and compliance certificate. Here, we are not at trial. We are not at trial. We are at the stage of the address, and that's the only thing I'm looking at. I'm not looking at trial. I'm not looking at the evidence. So I'm just talking in respect of your argument before the court in further disposition of your case to have the court to rule in your favor. That is your case. Your address is like the final conclusion after the trial to get the court to grant judgment in your favor. So issues that you raise in the trial or issues that you feel are of great importance that evidence for ahead of them, you give that cause that. There is a definition of what that sesame clusters. There will be probing, let me say, even under the Environmental Act, that talks about how and when damages or when the act of either a company or something can be said to have caused or occasioned. You understand what I'm trying to say? Do you know what I'm trying to say?
Yes,
So that's what I'm trying to address. Not your testimonies that you are taking, because you don't have that. Yes. So, and then when it comes to NOSRA is an agency of what? NOSRA is an agency of what? Of the state government, of the federal government, of the international organization, of
The federal government is.
so can they be sued in that capacity as an agency of the federal government? Yes? Yes?
It's not so.
They cannot be sued as an agency of the federal government.
For them to be able to show the court trust.
Yes? Yes?
My Lord, they can indeed be sued.
Thank you. He's an agency of the federal government. EFCC, all of them, are agencies of the federal government. They actually can. And there is the Public Officers Protection Act saying has to do with suing the public officer in his personal capacity. So if you are suing an agency, you don't have to make reference to the Public Officers Protection Act because you are suing a public officer in his personal capacity. So that is where the Public Officers Protection Act comes to you. But if you are suing an agency is an agency, you sue the Federal Police, you sue the Office of the Nigerian Police Force, and sue the very at federal. So the Public Protection Officers Act has nothing to do with this. But there is something that the law requires when you are dealing with suing a public agency. And what is that? A reaction notice. You must tell him a reaction notice that we have intention of suing for social reasons, for social whatever. So if there is an issue at all that arises from the fact that NOSRA cannot be sued or suing NOSRA, is because the reaction notice has not been given. And when the reaction notice is not given, it will automatically what happens to that case? It will be struck out. Because that is a condition required, it is a condition precedent to suing an agency of the federal government. You must give a reaction notice. And how many months? Is it 1 week, 2 weeks? How many months reaction notice before you file? Yes? Yes? 3 months. Thank you. So, talking about NASDAQ being sued, there is no public officer, you are not suing anybody in its personal capacity. You are suing NASDAQ as an agency, as a body of its own. I hope you understand that as well. Now, so let me go to the next thing I penciled down here, and that is, okay, I talked about regulation, I talked about the fact that NASDAQ sued his own capacity. Yes, I've told you that the community can sue the representative action in a representative action. So let's go to the second issue, whether the MOC acted negligently in the course of the situations. That has to have been established in your evidence. And that is only advocated or referred to in your final written analysis. I told that there must have been something to tell me to emphasize that fact in your final written analysis to show their capability and their acts of negligence. That for this reason, that PW1 or PW2, hello, that's where the evidence comes in. That PW1 in evidence as stated that so, the expert opinion, the expert opinion, which PwC access in evidence, establishing the fact that the action of this person has been performed and therefore urge your authority to hold that the action of so person is the reason for this so as well. You just take a blanket. So since you are formulated in law, you were able to formulate and say the fact that you must have businesses, you must have the survey plan, you must have things like that. You should have been able to now factor it in your final written agreement. That survey plan admitted as maybe exhibit or exhibit C goes without saying that the actions of so person was the one that engineered this fact. Do you understand? So that is why I call your address as cementing your evidence before the court. Do you understand me? So that both of you are failed. Yes.
We did adduce evidence. However, due to the short time frame between the last round and this round, the organizers of the competition, in their own mercy, decided that we should dispose of evidence, and as such, we're supposed to make this a fluid presentation, right?
Yes, from your fluid presentation, that is what I'm saying. If you are asked to do the real thing, you have in your mind what you're talking about. Where you have a scenario, you have fact given to you. That fact has given you the evidence to you. So arguments, the many things, they didn't ask you to dispose of that. They didn't ask you to dispose of that. And then, as a lawyer, short time is always short time. You never have time to that. If you finish a trial today, you have a trial tomorrow. You only have the hours in between to be there. So get used to it.
Yes, my Lord.
If you have 3 cases coming up on trial, the same day, and you may still be making the one and the defendants in the house. So you cannot tell the judge, my Lord, I just have the matter after 3 weeks just went to trial and I didn't have time to prepare for this trial. Do you understand? That's the new world. And unfortunately, I'm coming from a new course, not a Moot course. Yes. Yes, I know, but I expect that it's properly addressed. You understand? I expect that it's properly, I know. That's why I'm really not very good. Those issues were given to you, not to throw and think, but for you to make decisions, if you need to address issues, you need to address issues. You should, they are not smart. You are not smart. You are the one that I expected to say, if you are saying you have the capacity to do everything, you are the one that I expected to tell me that you have the capacity to do this one. So I'm making all these together so that you speak your own as it affects you. And then collectively you also learn something. So now when you are establishing a case of that you have to do the actions of the agency concerned after the expected also has a statutory authority to impose the fine and the settlement from the Nodal Act at the same time. Because assessment is different from imposing. And it says assess damage, not assess and give compensation. No, you are just assessing. And when you assess, the law order says that you will work with other agencies and even with your experience. And then there is one thing which I expected you to react to, ask Daddy, and which you fail to, which you can make essential to your case. And I will give you an example before I say this. When I was practicing, I had a case before me and it was said still. I object of the opportunity of trying to draft the case settlement between the defendants and their complainants, but she refused. She said a lot of rubbish to me that the young counsel trying to. And then we got caught. The court was a state court at a shop. I That was when MTN and others just came out. And we have shop selling MTN recharge cards. You cannot buy recharge cards on your phone there. You have to walk up to a store to get recharge card on the piece of paper. So she was a major distributor of MTN. And then she claimed that the board stole money. She calculated it was almost at 2 million naira and and when she presented that evidence before the court, 80% of what she said was, she was listing how the boys told us that to me. And 80% of it was, I owe you. Like the boy took a loan, I owe you 5,000, I owe you 2,000, I owe you 1,000, I owe you missing 5,000, missing 10,000, missing unaccounted. And the only thing I define before the court is, what is evil? Does that definition accommodate IOU or missing or unaccounted? If you are saying somebody has stolen, then you must prove the fact that it is. But not without the consent of the owner. I owe you is with the consent of the owner. That's nothing. Missing means both of you identify the fact that this was missing. That is not stealing. And that was the distinction I gave the court, and the guy, the boy was the guy that was missing. So here we are talking about the assessment class. If you have read the nurse that it only talks about all spillage from beginning to the end. I expected you to tell me that assessment class is not within the confines, the authority, and the jurisdiction of yes, you mentioned the fact that not that what happened was assessment and that the oil spillage and that I wanted to put it the right way. You said what happened was the assessment and that no cannot afford to give, it's not their decision to impose a fine or whatever on you. Not that it's not within the jurisdiction of the Notarial Interference. That jurisdiction is a clear cut exception. It is not their jurisdiction. They should not even go ahead. It is not their decision to go to that level at all. At all. It's an issue of their decision. What does the law say? What does the judge say? It is not their decision. It's the only thing I expect you to say. Not that the family should not do that, we cannot do that. It is not. No, they don't have the decision to even go to that area at all. I hope you get what I'm trying to say. So, and that's why I said that defining seismic classes would have been an advantage. We thought that clear-cut defined what the decision of Muslim is about. Do you understand what I'm trying to say? Seismic class does not mean that there was no spillage. And even from what they are saying, there was no spillage. They are only saying that it destroyed properties. And they essentially use the spillage. When you have a point that is essential, you hammer on your points. Not put it in personal. That is the reason. Like I said, in that case, what I emphasize in the court is I owe you the same thing as stealing. That was the main in my address. And I made the court to see that as criminal, not as a person. If I said that in person, the court would not have said it. But if I made it an issue, or I made it an issue before the court, if I made it an issue, and that is not within the jurisdiction of not in your definition is an records. Not just saying you don't have a part of it and it is the plan, part to avoid the investment. So I hope you understand that. So when you have it before you, and when you have matters to decide, after you identify the principles, you identify the laws, you look at your case, you identify the facts, and know where the law aids your case, or the principles aids your case. And if you identify your case as a fraud, you know what law can aid the law in your case. Do you understand what I'm trying to say? Do you understand what I'm trying to say? But on the whole, I must confess, you both did well. You both did very well. Your arguments, your presentation, and your approach, you both did well. But there must always be a winner. Abby? So let me ask you before we proceed, is there anything, any question? Any question for me?
Your Lordship, thank you for the guidance. I would like if you could provide guidance on how you would have approached the issue from the purview of Nostra, saying that there was an avalanche of case law and statutory authority that precluded Nostra for instituting this action, imposing the levy, which we understood to be points of law. But for Aguendo, because this is a Moot court competition and we've had an obligation to argue, we just had to rely on AIE and others to try to make our way. So
Yes, I know.
Yeah.
In the first instance, I know Nostra is being like not as opposed a levy to that. And if they add, and they have been sued at that, and they have come to court, the court will have decided that they cannot impose such a levy. Like that decision.
Thank you very much.
Yes, any other question? Yes, any question? No. You are sure? When you are placing advocacy has goodness and in those days, the saying goes that when the lawyer is the court and is failing, the client will be so happy. And that pocket behind the gap, the client will just come up and talk money, saying, I'm impressed. I want the lawyer, this is you. But I know very well, each of our offices is the present actions, is just coming from the So I know that is just to tell us the importance of confidence and the importance of diction and the importance of confidence when you approach the court. At times, have you, when in practice, you used to crack a joke, like when you are saying nonsense, say it confidently. That when you are saying nonsense, you say it confidently. You understand what I'm trying to say? I can see a bit of timidity when you are talking about when you kept your eyes down most of the time. You were not free with your presentation, right and left. You gave me the impression that you were reading, but I knew you were not reading because you kept looking down at others. All I can say, you were trying to avoid contact, facial contact. But you need that. Face your fault, face the judge. It is not a lack of, it is not disrespect. It is confidence. You know, it is confidence. So I feel that bit of timidity within you. So in further approach in the future references, when you have to report, ask confidence, not say the truth. Say confidence. You understand? So you are right, I must confess, given the short time you had to prepare for today and your presentation before take any one of you as my answer if I may. And I don't know if I can take your cards so that in case I need your legal counsel, or I can call on any one of you to come and represent me. And that's factual. I can put my name on any one of you. So thank you for working hard on this.
Thank you, madam.
So for today, I believe I've tried to who is my one. All right, in grammar, seat 8 had 15 marks. Seat 20, 18. Legal points, seat 8 had 25 marks. Seat 20, 28. Legal authorities, team 8 at 25 marks, team 20, 25. Dress compartment, court etiquette, and I added presentation to that. Team 8 had 14 marks, team 20 at 17. Total score, team 8 at 79 marks, and team 20 88. Thank you. So once the data is so much, and God is very good.
This is actually I've also considered the issue of jurisdiction as being very relevant to this case, and it has been held by Supreme Court in the case of Chief versus Chief Registrar Federal High Court and others, 2024, LBLR 62976SC, that, and I quote, the issue of jurisdiction is roundly accepted as a foundation stone upon which the court can competently exercise its adjudicatory powers. It's a threshold issue which can be raised at any stage or time and in any manner by the parties or even the court so much in the litigation process. See Rolling Contours vs. Memorandum 1983, 1 SCNLR 296, African Newspaper, Nigeria Limited, Federal Republic of Nigeria, 1985, 2 Nigerian People Reports, Part 6, page 137. And this is Esther Adeshigbe vs. Military Governor of Lagos State, 2017, 10 Nigerian People Reports, Part 1574, page 442. End of quote, Palmore, Asiemo, Abraham, and Gomez, GSC, that's page 17, paragraph 3 I must consider the view that though the case before the court appears to revolve around the alleged issue of negligence by the claimant, which led to the finding complained about, the roots of issues lie in oil exploration activities of the claimant's company, and as such, this case should have been filed before the Federal High Court and not the State High Court. See Section 251 of the 1999 Constitution of the Federal Republic of Nigeria. Further, in the case of SPDC vs. Bobe, 2021, LPLR 56486C, the Court of Appeal held that, and I quote, Section 2511N of the Constitution of the Federal Republic of Nigeria stipulates that, notwithstanding anything to the contrary contained in this Constitution, and in addition to such other jurisdiction which may be conferred upon it by an Act of National Assembly, the Federal High Court shall have and exercise jurisdiction to the exclusion of any other court in civil causes and matters relating to mines and minerals, including oil fields, oil mines, oil mining, geological survey, and natural gas. The document of Section 251N of the Constitution gives exclusive jurisdiction to the Federal High Court relating to the matters listed in paragraphs HS or subsection 1 of the said clause will have exclusive jurisdiction therein, and the jurisdiction of the State High Court JCA, that's page 17, paragraph 8b. It also says that jurisdiction cannot be waived by parties. See Okolo vs. UPN, 2004, 3 Nigerian People Report, part 859 at 8, at page 87 and page 108. It has also been held that the court will consider the issue of jurisdiction along with the merits of the case, as long as the issue of jurisdiction is taken first. Sitting President of the 2004, 9 Nigerian People Report, part 878, page 251 at 274. One point being said, I will consider the opinion that this case ought to have been filed at Federal High Court, leaving the court to the exclusive jurisdiction to get cases related to oil exploration and minerals or mining. That being said, I shall also, however, consider the case of merit in the event that the court is found wrong on the issue of jurisdiction. Issue 1. The settled and facts which are admitted in no vulnerable. CUD, PLC, and another was from Jakaba, 2007, LPLR, double 309 SC. It's not in dispute between both parties that there was a specific class which resulted in damage of over 250,000 houses. However, what is in dispute is whether the specific class was due to the action of the claimant. The claimant has denied culpability and rather passed the buck to the activities of unidentified individuals, while the defendant has put the blame squarely on the claimant. I must say that there is nothing before the court to show that the specific class was caused by the claimant. There is no direct evidence to this effect, and there is no admission from the claimant. Defendants have relied on circumstantial evidence in the blame on the claimant, and it has been held that for circumstantial evidence to lead to a finding of culpability, same must point directly to the liable party, leaving no room for any other explanation other than his culpability. Circumstantial evidence before the court does not point on referring to the claimant, and same and not on others of culpabilities establish liability power to act as it has done. Section 6 and 19 of the Act do not donate to the agency the power to impose the levy it has done. Section 6 deals with the objectives of the agency, while Section 19 also deals with the powers of the agency to assess, supervise, monitor, and enforce resolutions of issues arising from oil spillage. In this case, there is no evidence before the court to show that there was any oil spill arising from the assessment class, which means that the damage as identified in this case falls outside the scope of NOSRA. Sequel to the following, I find that NOSRA acted on the various powers. This issue is therefore resolved against the defendant. In the light of the finding in issue 1, that the claimant cannot be held liable for assessment class as a result of the paucity of evidence, issue 3 becomes moot and becomes a mere academic exercise. It settles that as Court of Appeal was held in the case of Abubakar Osogimani and others 2021, LBLR 5684C, and I quote, "It is a principle of law that general attitude of the court is to shun making pronouncements on academic or hypothetical issues as does not serve any useful purpose." This charge of care and another was Dr. Muhammad Ramon Biko and others 2013, all best of LBLR class 693 page 1853 Monica Donmanesen KCA as page 22 paragraph B to G. Issue 4. One stated straight away that portion of the Public Officers Protection Act extends to public officers personally and not public agencies as a body of public. In Bureau of Public Enterprises, such as the Insurance Acquisition Group Limited and others 2008, LPR 8560C, the Court of Appeal held that, and I quote, "The objective of public officer 30, dress of ordinance report etiquette 15 out of 20, bringing the total to 78 points out of 100. Therefore, the winning team for this semi-final is OANMCC 25/002 with a total of 81 points out of 100. Yes. That being done, questions? Questions? Yes.
Love to ask a question.
Yes.
The issue of Atuba.
Yes.
Lord, which court has jurisdiction to consider the issue of Atuba? The first question. Well, the second question is, in a situation whereby the act of the public officer or the agency is ultra virus, is there going to be any statute applicable in such a situation?
Well, your question is somewhat confusing. I'll try to answer it based on what I think you're trying to ask. And I'll start with the first question. The first question of the case being started by what the judgment said is that the case is not statute bad. Why is it not statute bad? Because the act which the defendants have relied on, which is the Public Officers Protection Act, applies to the public officers personally and not to government agencies. So that act cannot be used as the law upon which the defendant rely on the argument that your case or the case of the claimant is barred by the statute, because the case was not instituted against any public officer personally. If a public officer had been joined to the case personally, the outcome might have been different. But because the action is against the agency and not officers acting in their personal capacity as public officers, that act cannot be relied upon to say that the case is statute bad. Do you understand? Now, as to which court will have jurisdiction to say whether a case is statute bad or not, the court that has the jurisdiction to entertain the case at all in the first place is the court that will say the case is statute bad or not. In this case, the fact as was relayed is that the case was filed before the Bayelsa State High Court. And because, as I said in the judgment, this case has its origin in oil exploration. Issues affecting oil exploration lie within the exclusive jurisdiction of the Federal High Court. So the case should not have even gone to the State High Court in the first place, which is why the case ended up being struck out rather than being dismissed or whatever. So do you understand? Any other question? Any other question? From the gallery, not necessarily from participants. Alright, in the absence of questions, I'll give you a few observations that I made. First, I'll commend the students who appeared as counsel in this case. Both sides did well, both sides advanced their arguments in a compelling and logical manner. The presentation was good, the quality of the address was good, a bit verbose for the defendants, because I'm informed that you were asked to limit your presentation to 12 pages, and I have an address of about 21 pages before me from the defendant. So your address was a bit too much on the left side. However, the quality of the local arguments pretty compelling, and I must say that continue on this trajectory and more faculties of law set up avenues like this for students to engage in mock court competitions, the level of advocacy and legal expertise that we have will be improved upon as you come out of the university. However, in your appearances, let me correct you. Once you announce your appearance in court, when you stand to speak, you do not need to say your name any further. Why? Because you have announced your appearance and introduced yourself to the court at the beginning of the case. So the court is expected to have taken notes of your name. And because proceedings in court are recorded, you do not need to remind the court that once again, I am so and so, because you have announced yourself, the court has taken notes of your name, you've announced your colleague, the court has taken notes of your colleague's name, and the court, for any reason, has to ask a question, the court knows the name of the counsel. So to have to stand up each time to say, I am so, once again, I am so, it's not particularly in line with the practice and procedure defined for court. If you have the opportunity to visit courts and observe court proceedings, you will not find lawyers in court announcing their name each time they stand up to address the court. On the whole, congratulations to the winning team. The side that did not win did not perform poorly, but of course, in any competition, one side has to win and one side has to come in as the runner-up, not as the loser. So to those of you who have come in as runner-up, to be better luck next time. Sometimes the case is won and lost on the facts that the party is giving. Some facts, there's really nothing that you can do. You just show the best of your ability, but you'll end up still with the short end of the stick. So which universities are represented here? Interesting.
University of Benin.
University of Benin. All right. You're well up. I think that